four of us, four
That's
defense
the
lawyers.
advantage of being a defendant.
It was fun. No, well stressed. You know, we just talked science and law.
And Mike's on there.
Okay.
Where's Catherine?
I don't blame him.
I had stuff here I wanted to take with me.
You can't take stuff. It doesn't.
I don't hear it.
You can't take stuff.
I don't hear it.
He said you're not allowed to take the stuff back with you.
Tell Catherine to give it to Stephanie to bring it to me.
Okay.
Yeah. Thank you.
All right, we're back in session. People versus Robert Durst. Mr. Durst is present with Mr. Chesnoff and Mr. Ray, and Mr. Lewin and Assistant Head Deputy Bailey and are present for the people, and Mr. Beata, Mr. Milius. We now are going to hear the balance of the argument. Like the last argument, this is broken into parts by necessity. This is the defense motion to exclude evidence of handwriting comparisons under Sargon. And of course, I've read your authorities. So,
Your Honor, the court last time we were here, when we had the benefit of a transcript, did a very thorough outline and analysis of the position that we had taken. And in response, the state filed various declarations in order to supplement their position, which most respectfully, Your Honor, we don't believe the declarations actually moved the ball much forward in terms of the state's position. We still maintain that Mr. Muhammad should be excluded from trial. Basically, Your Honor, his declaration simply vouches for Mr. Cunningham, and at best would be considered cumulative. Mr. Osborne should be excluded at trial. As the court recalls, he was first retained by Mr. Jarecki. He didn't submit a declaration and would also be cumulative to Cunningham. At most, Lloyd Cunningham should be permitted to testify. You already stated that Mr. Espley and Supervisor Connor from California DOJ cannot testify. The only thing that Cunningham really talks about is that, to some degree, that Muhammad's initial reports were conclusory. Cunningham should be strictly limited to testimony regarding the alleged similarities and lack of similarities in Mr. Durst's writing and the cadaver note. He cannot, as the court stated at page 41 of the prior transcript, lines 1 through 11, opine specifically that Mr. Durst is the author. As to Cunningham's other opinions in this declaration, the court merely has to track the arguments we made in our supplemental brief. Cunningham's opinions are based on his experience and not supported by the reliable methodology that this court has already acknowledged is necessary. With respect to the question of whether or not we can raise during the trial the reports of the supervisor and the original handwriting examiner that another person actually wrote the note, the court, as well as the state, have acknowledged really how terrible job those people did and how actually it could probably border on some form of obstruction, and said that they wouldn't be allowed to testify. We have asked in our supplement, Your Honor, and the court allowed us to do so, to consider allowing us to bring out the fact that another person was identified, not for the purpose of doing anything other than establishing that there were other suspects and that police investigative tools do not always rise to the level they should, and it would provide the jury with the knowledge that handwriting people can be wrong. And in fact, police handwriting people can be wrong. So we would ask you not to allow us to introduce those reports necessarily for the identification they made, but rather for the fact that the state and the court have recognized that that identification was faulty, especially in light of the perjury, or I don't want to call it perjury because it wasn't under oath, but the lie that was told by the supervisor, who later acknowledged that she only rubber stamped it. We feel very strongly about that, Your Honor, because in the course of our defense, there will be multiple representations about the way the investigation was conducted, especially in light of the fact that there has been a concession already that there's absolutely no forensic evidence having been retrieved from the scene, even though there's multiple possibilities of other people that we will present at the time of trial. Not necessary for us to preview our defense, but with that said, Your Honor, I don't think anybody should be allowed to testify that Mr. Durst is the author of the cadaver note. I think the court has observed what is allowed and what is not allowed. They can give, Mr. Cunningham can give his opinion as to why certain thing, but the ultimate decision is up to the jury to decide, and the court's going to so instruct. I might review my notes for a moment, Your Honor, knowing that you've been through this before. But with that said, Your Honor, I think the strongest thing that can be said is that the declarations do not necessitate now a Sargon hearing. I think the court can garner enough from what we've argued and what they've written to make a reasoned decision as to what should occur going forward. If you have any questions, Your Honor, happy to answer.
No, thank you.
Thank you, Your Honor.
Your Honor, I want to address this very carefully and very completely because this is an incredibly important issue. The handwriting evidence in this case is absolutely central to the people's case. And I want to start with how we kind of ended up here. We ended up here because the court made the observation. The court said, quote, "I believe that even a handwriting expert proffered under 1418 likewise ought to be screened. I don't think that's a difficult task." That's what the court stated. That was during the July 17th hearing, page 25, line 27 to page 26, line 3. Now, the court also said, as the court remembers in dealing with this issue, the court said that the reports that the court had from Lloyd Cunningham and from John Osborne were incredibly detailed. The court noted how helpful they were. The court specifically said, in at least 2 instances, the experts have offered superior handwriting comparisons which are quite methodical and thorough. As the comparison of writing, Lloyd Cunningham's methodology is exceptionally useful. It will assist the jury in its comparison of the documents so they may fulfill their fact-finding rule under Evidence Code section 1417. The court added, "I'll turn first to the opinions of Lloyd Cunningham. His observations, his analysis are extremely methodical, very, very useful." Sure. The court added, "I'll turn first to the opinions of Lloyd Cunningham."
I'm sorry, I said this and now there's a transcript of it. It's in your brief and now you're saying it again, which is now going to be in another transcript. So there's this echo thing going on. But I appreciate, you need only reference the point and I will instantly apprehend what you mean.
Understood, Your Honor. So the court indicated during this ruling that the court's position was that these experts had not laid out the complete methodology and, in essence, the reasons why they came to the conclusions they came to. Now, the court mentioned, with respect to methodology, with respect to opinions, the court discussed 2 that I recall. One was the court said, listen, your expert is saying no 2 people write the same thing the same way. And the court said, hey, where is the authority for this? Where's the, et cetera? The court said the same thing similarly to no person writes the same thing the same way twice. Now, at the time, we related to the court, Your Honor, part of what's going on is that you have experts who are writing a report, and as detailed as these are, it would be nearly impossible for an expert to go through and defend and articulate, almost defend their thesis to that degree. We went out, Your Honor, based on the court's ruling, and we paid these individuals a lot of money to go back and here's the issues, here's how you came to the conclusions, which they did. Now, it's important to note, we still have not heard from the defense, Your Honor, one declaration, one witness, one iota of evidence that anything that these individuals did was improper, was not, if I continue, was not within the standard of a handwriting analyst. What we heard was, we have a law professor who has been specifically prohibited from testifying to this kind of evidence in a Cal Supreme Court opinion in Lucas.
Right, but remember, this was at the admissibility hearing that he could not testify. And as to the question of whether he was improperly prevented from testifying at the trial, the defense took the position that it was futile because the trial court had disallowed testimony at the hearing. The opinion, the Supreme Court says that's not so. That's they didn't actually decide the point of whether he ought to testify at trial because, or whether it was admissible at trial because the question had not actually been presented.
Right, but this is the admissibility hearing. So, Your Honor.
Right, I won't hear,
Right.
just as in that case, I will not hear from that expert at the admissibility hearing. I'm gonna rule, and you may argue whether or not he ought to testify at trial, but that's not gonna be the reason.
Right, and Your Honor, to continue, what that expert put in his declaration, and again, even after we filed our supplemental declarations, which Mr. Chesnoff said were insufficient, they quote, haven't moved the ball, etc. I don't know how you can move the ball anymore. They're about 50 pages long each. I'm very comfortable in saying, I don't think there's been a handwriting expert in any case in the history of the United States of America who pre-trial in a criminal case has submitted this kind of validation, justification, methodology for the opinions that they're going to give.
It's about time.
Yeah, so that is kind of step one relating to this issue. Now, the court, Your Honor, and this is partially our fault in apparently not explaining to the court a little more carefully about Linton Muhammad. Now, I think his declaration spelled it out. Linton Muhammad was assigned to do the same thing that Karen Chiradi was supposed to have done originally. Now, Linton Muhammad did an independent examination. He made his determination independently, but as happens with the ASCLAD rules, ASCLAD, that the laboratories have to follow and which many expert witnesses in the field of forensic document examination follow as well, you have to have a second person sign off, look at the original results, come to their own independent opinion, and then sign off on the other person's report. So, Your Honor, it's not that Linton Muhammad did not write a report. His report is absolutely, Cunningham's report is adopted and included by Linton Muhammad. And I think now we've spelled that out in the declarations. Now, with respect to Mr. Osborne, we have chosen at this point in time, he is very likely, if we call him at all, going to be a rebuttal witness. If and when we get to the point where we are going to offer Mr. Osborne's testimony, we will file a similar declaration. Now, one of the issues that is hanging in the background is as we sit here, Your Honor, we still don't know whether this is even going to be an issue. We have not been told yet whether, in fact, the defense is even going to contest the handwriting. But let's assume, and everything I'm going to argue has to do with the idea that they are, in fact, going to contest the writing. So, let me just, because I don't want to go through it more than I have to. Does the court need any further argument about the peer review issue with Linton Muhammad?
No.
All right, so does the court need any further argument? I did not, as the court's aware, in our moving papers, I did not go back and go through each opinion that the witnesses gave in their declarations and explain them. I assume the court doesn't want or need me to do that now, am I correct?
That's correct, Mr. Chairman.
So let's move on to the next issue, which is crucially important. 1418, Your Honor, is very clear that a qualified expert, and these experts are more than qualified, can testify to identity. Now, there is nothing that is in Lucas which in any way changes that. And I just want to address...
Don't make this argument.
Your Honor...
I guess it's good for you. I mean, that you have another basis to uphold what you expect my ruling is going to be. But But seriously, if the argument, if Sargon didn't exist at the time, and so no one's going to make a Sargon objection at trial, therefore the Supreme Court's got no business applying Sargon after the fact without a factual basis.
Your Honor,
I understood your argument, but it's like you want to win every argument. You don't have to win this because I don't think it's true. 1418 is necessary but not sufficient, right? Let's say you've got 1418 that says they can give an opinion. What if the opinion is somebody quoting somebody else who read in a book that was the opinion? It's hearsay. It doesn't come in. So 1418 lets it in, but it doesn't always let it in. Likewise, if there isn't a foundation, a soothsayer told me, I visualized him writing the notes, for instance. Imagine that. Right. Is that now admissible because of 1418? No, it's not. So don't make that argument.
Then let me ask the court this, Your Honor.
Yeah.
Do I need to, at this point, do I need to spend more time explaining to the court why these experts should be able, under 1418, and given the declarations they filed, to be able to give an opinion on identity?
No. I think that you've done what I asked.
Okay.
There's one little caveat. I'm going to go into it, and we can talk about
Okay.
it.
Then I'll hold off on that for now.
Okay.
Then let's go to the next area, which becomes important. And it was very confusing. Defendant, I'm going to talk about Denbaugh for a second, and this is going to go whether he's called a trial or not called a trial, but this is the issue that we're going to have. One of the problems is that Professor Denbaugh, in essence, wants to say that handwriting and handprinting are not reliable. He wants to talk about other states that don't admit it, etc. He wants to talk about how handprinting is different than handwriting. And here's the issue. The problem is the Cal Supreme Court has rejected every one of his positions. So the question would be, if he's going to testify, is an expert with the court's gatekeeping role, is it proper for an expert to, in essence, say, listen, handwriting's garbage. I don't care what the Cal Supreme Court says about admissibility, so then what do? Do I call the Cal Supreme Court here to testify? Do I have the court take judicial notice and read to the jury that, in fact, the Cal Supreme Court has specifically stated that handwriting is admissible in California?
No, admissible is not relevant. So the question you're posing is, does he in fact have a basis for the assertions he's making? So merely because something is admissible doesn't mean that the jury must automatically accept it. So the defense must be allowed to, with admissible evidence, if they like, contest the accuracy or reliability of the handwriting comparison in this case. And so part of that might be an expert opinion that no one could ever do such a thing. If there's a basis for that, whether or not it's inadmissible in other states, I don't think that comes in. But I am willing to scrutinize the testimony, but as a general principle, I don't think I exclude it simply because the evidence, the contrary evidence, is admissible.
Oh, Your Honor, I want him to testify. I'll gut him like a fish. The problem is going to be,
again, a sports metaphor.
The problem is
Not
going
if
to
you're
be,
the fish, you're
I just want to give real clear warning and information to counsel that if you're calling somebody who's going to attack the whole field, who's not even a handwriting expert themselves, then this is the cross you're going to get. But so moving on from that,
I'll let him know, Your Honor.
okay, we now move into the whole issue of believer and charity. And I think it's important to look at the history.
Yeah, I'm not going to let it.
And the third-party culpability argument, I just got to say this. It's, I don't know, disingenuous, malformed, but here's the argument. We want to bring in the misidentification of Niall Brenner. We want to bring it in to show that Niall Brenner actually wrote it, but we don't want to bring it in for the truth of the matter asserted, but it's actually only relevant if in fact he wrote it, and we want to bring it in even if none of that matters because we want to show that the investigation is corrupt. Wow. That's a handful and it's got 352 written all over it. So, Your Honor, with that in mind, I think this is for me one of my shorter arguments ever. Based on what the court has said, Your Honor, subject to the quote, I think you call it a caveat or whatever, the
Caveat.
The caveat, Your Honor, we'll submit.
Do you wish to respond now?
Only this, Your Honor. court has indicated that you might rule against us on the issue of whether we can present the information to the jury that police investigators in this case made a dreadful mistake or had a theory and then lied about it. If the court's going to deny that, we have a record made on why we think that the jury should be able to hear that the LA police investigation was flawed. With that said, Your Honor, I have nothing else to say.
Okay, well, we'll talk about that, and of course, you phrase it as persuasively as you could, but I mean, it's based, first of all, on bad science, and second of all, on we'll talk, again, I kind of previewed this when talking about the difference between a theme and a defense. You may get in evidence, there may be evidence from which you can imply that the investigation was done poorly. But as far as presenting a case about a bad investigation, that's not going to be relevant. It's not going to be relevant. So I'll discuss it specifically. Let's just go over what we're doing here. So Lucas holds that the method of handwriting comparison offered by the prosecution was not sufficiently scientific to require a hearing under Kelly. We agree with the trial court's determination. The handwriting comparison utilized here merely isolated and carefully compared readily observable aspects of physical evidence. So we're not really talking about scientific testimony. We are talking about expert testimony, and my main concern for the jury with expert testimony is this. The testimony can't be ipsa dixit, which is really fun to say. Ipsa dixit. It can't be, I am an expert and I say this is so. And that's not good enough. And I'm obviously saying it in a tone that emphasizes its possible abuse. And not that the experts aren't trustworthy, but even if it's not science, still there have to be objective bases. There have to be guidelines and criteria for rendering an opinion, and I need to know what those are. So there are references to various ideas in handwriting comparison that were not supported by anything. And you've explained why that was so. So now I've asked for you to document the basis for such opinions. Now, you know that I've spent a lot of time thinking about DNA evidence, and that's the gold standard. It's quantifiable. It's
science.
You know, it's science, and it's probabilistic. It's more, I think, more reliable. So, nevertheless, any expert testimony, whether scientific or not, still needs those objective bases. So, even if evidence is let's say, even if I'm skeptical of evidence that's presented, that's not my job here to decide whether I am skeptical of evidence. What I need is what Sargon commands, and there is reference to Kumho Tire and Daubert, and those cases that describe the what is sufficient and what is not, as far as a basis for an expert opinion. I would say generally that what I've seen here is voluminous. Certainly, it's consistent, and it's pretty convincing. I'd say that handwriting can be individualized. It's not scientific per se, but it is supported by more than mere opinion. Let me talk about these things specifically, and I'm going to contrast what is supported by something that is not, with something that is not. I do think the defense brief was a good guide. It was well organized. All right, the argument is that John Paul Osborne should be excluded from testifying at trial. The people have indicated they're going to file a brief if he does testify. I think he may rely upon the support for some of these ideas generally supplied by the other experts. In other words, I don't really want to have each expert testify to the basis over it. That would be cumulative. Whereas the shared notion of what a proper basis is for an identification, I think, is sufficient.
Your Honor, on that issue, what we would likely do is, given what the court has said, we would likely have Mr. Osborne look at the declaration, and then affirm that he agrees or does not agree. And if he agrees with it, we would file simply a declaration saying that he is incorporating those two declarations into his opinion. And as the court very soundly realized, it's supported for any handwriting expert,
right,
the position in there. So that's what we'll do if the court is, if that's acceptable to the court.
So I ruled previously that he may testify, that Lyndon Mohammed may testify, that Lloyd Cunningham may testify. First of all, the defense specifically complains about that Mr. Durst tried to change his handwriting where there was alleged unconscious reversion. And that's interesting. I think there's a reason that was put first, because immediately I was skeptical of that also. And I think the problem here is not substantive. I think the label is poorly selected. This idea, unconscious reversion, they picked this term to describe this dynamic that is described by a number of studies. Now, unconscious is a Freudian or Jungian notion, and we're certainly not going to hear expert testimony about that. These folks aren't psychologists, so I do think it is the label is inapt, but functionally, substantively, there is support for this idea of reversion to one's prior style of writing. Secondly, the defense objects that Mr. Cunningham should not be permitted to introduce his opinion that no two persons write exactly alike, that frequent repetitions by one individual establish habit patterns that are difficult, if not impossible, to imitate successfully by another. There were quite a few studies here. Now, some of them are conducted by Mr. Cunningham himself. I don't think that necessarily eliminates that from consideration. It's more than a mere guess. It is actually objective. It can be criticized. The lack of peer review on some of these is significant. It could be a basis for exclusion, but it's not the only consideration in determining whether or not expert testimony is sufficient to satisfy Sargon. Again, I'm not here to judge whether this is persuasive. I'm here to decide whether there is some logical basis, some reason, some evidence to support the idea. The third complaint is Mr. Cunningham should not be permitted to introduce his opinion that two bodies of handprinting can be deemed to be the handprinting of one and the same person only when they agree in every fundamental element and quality, and if they embody no basic differences. I found support for that in the materials. He should not be permitted to introduce his opinion that no person writing freely and normally ever writes the same thing in precisely the same way twice. There is evidentiary support for this. Mr. Cunningham should not be permitted to introduce his opinion that frequent repetitions of the writing act by one individual establish habit patterns that are difficult, if not impossible, to imitate successfully by another. So there is a criticism that impossible in the defense views hyperbole. Nevertheless, that conclusion, there's support for the conclusion. I don't know that it's undeniable, but there's support for the conclusion. So it would be admitted. Mr. Cunningham should not be permitted to introduce his opinion the cadaver note and the envelopes were spontaneously executed. Moreover, he should not be permitted to opine that there is no handprinting evidence to indicate that another individual attempted to imitate Mr. Durst's handprinting by freehand simulation or tracing. I believe that was supported by the declarations. Now we get to those are the complaints about from the defense. There is still one element of this testimony on which I am not satisfied, and I'm skeptical that I could be satisfied, and that is I see in every instance there's an objective basis for identification testimony. I do not see the objective basis for relative confidence. So the justification for this, and it ostensibly protects a suspect because a person is very confident or kind of thinks so, or think not, that maybe, that those kind of terms, I'm obviously mocking it by putting it in different terms. They actually put it in pseudo quasi-scientific terms, which I think lends a scientific veneer to opinions that are not scientific. And the justification for this is reference to the Scientific Working Group for Forensic Document Examination Standard Technology, SWIGDOC. And SWIGDOC is, so it's a committee that decides a fair way to express these things, and it may well be fair, but what the people have shown is something that is binary. It is or it isn't the handwriting of this person, and various related claims, which, but as far as the identification, it's binary or not. And I think the degree of confidence, the connotation of confidence it suggests that it's probabilistic and quantitative when it is not. So I just don't feel there's any support for that other than a committee agreeing on language. So that part I wouldn't allow.
Your Honor, just so it's clear, because I want to advise our experts, so it would be my understanding, first I want to say what we can't do. We cannot have the expert get up and say, to a reasonable certainty or to a reasonable scientific certainty, I believe Robert Durst wrote this.
Yeah,
we understand that's out.
Yeah.
If I explain to them what I believe they would say is based on my experience as a handwriting analyst, based on my training and experience, it is my opinion that Robert Durst is the author of this document. Am I correct?
That's right.
Now, then the issue would be that in cross-examination, the defense has to be very careful not to open this thing up, because in the end, Your Honor, they can use your ruling as a shield. They should not be able to use it as a sword.
All right.
So, Your Honor, if the defense starts to ask questions on cross-examination regarding how certain are you, what is the basis of your certainty, etc., they're potentially going to elicit a response from the witness that, in other words, I'm trying to tell my witness what to say, but they need to understand that they can open a door they don't want to open. Fair, Your Honor?
Right. And they'll hear the jury about SWIGDOC. Okay. So now let's move on to the next, we've gone through the shield, now the sword. So the defense should be permitted, they claim, to introduce evidence that Niall Brenner submitted writing samples to LAPD, William Weaver, and Karen Chiradet, I forgot what's her name, identified Niall Brenner as the author of the cadaver note, and subsequently changed that assertion to implicate Mr. Durst. So, first of all, the science was junk. There was a lack of methodology here. It was false. But then we just don't have, we don't satisfy the admission of People versus Hall. It's not, so supposed evidence of motive is not enough. Motive, opportunity, it's not enough. There has to be actual evidence connecting this third person to the commission of the crime, and there is no such thing here. Here is, and I misspoke earlier, here's where the defense quotes Kiles versus Whitley, which is really, really interesting, because it really, Kiles versus Whitley says, it does say a defendant is in that case was entitled to discover evidence to attack the reliability, thoroughness, and the good faith of a police investigation. Interesting. So it's dictum. Secondly, it's federal, it's a constitutional right to discovery, but it's not, this case doesn't stand for the admissibility of this evidence in this context. You can't say, well, Kiles versus Whitley means that we get to put in evidence of third-party culpability on the grounds that it shows us the police, blew it, not identifying this third party. But it's a red herring, right? So it's.
Your Honor, could I just make one comment? The point I think of the evidence from our perspective is you had an investigative team that had a suspect, and so they produced the evidence to go after that suspect. They then later had another suspect. They decided to produce the evidence for that suspect. That is relevant to determine not only the reliability of the methods they used, but the reliability of the investigative team to actually produce the truth. Okay, so the reliability of the investigative team to produce the truth is irrelevant. That is immaterial. What is relevant is the evidence that the witnesses testified to. Okay, their investigation is not relevant. No, the jury will not be told consider the reliability of the investigation, their capacity to produce the truth. They're not going to hear that. It's not material. And then the other part is the evidence is false. Respectfully, Your Honor, if in fact there's an investigative team that decided to set somebody up because they figured that he was the one who did it, and then they decided to focus on somebody else, and they switched and said, okay, we're going to set that person up, that clearly is relevant to whether the jury should believe anything that they are told by that investigative team. And so that's what we're saying here, is that you have a situation where there is, we believe, an evidentiary basis to be able to say you cannot trust what you're getting from them at all.
I see. So the police officers suspected someone, and then they go to a handwriting expert who does a terrible job, and had the handwriting expert done his job, he would have ruled out Niall Brenner. But he didn't. In fact, he's rubber stamped. And then then we see that this was a rubber stamp. So now you're blaming the police officer and saying, when the officer testifies, and what the officer testifies to, I'm not sure, the condition of the crime scene, the fact that they talked to the defendant, what are they testifying to that either,
It's the bias of the team that we're talking about.
And the bias of let's say the team is biased, then what? What's that proof?
The jury doesn't have to listen to what they say. It has a reason to disbelieve what they have said about other issues.
And I see. And what specifically is it that that you suspect that the officer will testify to? This is not a drug bust. This is not the officer saying, I caught the guy with the cocaine. This is the officer who amasses evidence of other people's statements.
But there are examinations that are done at the scene of the crime, which are then interpreted. They're pointing the finger at this.
I see. So okay, now you're talking about the scene of the crime. So you're talking about you're attributing to each member of the team that collective bias. So it's a conspiracy that you're proving.
one that we can argue, yes.
I don't think a defendant is foreclosed from telling a jury that the police engage in misconduct, and that's a basis for not convicting somebody. Or
Wait, if there's admissible evidence from which one can infer misconduct, go for it.
Well,
You have at it, but you have to get the evidence in. It has to be admissible evidence that the police officer, didn't look under this rock over here. I mean,
but you're up.
If he's at the crime scene, sure, I get that. That's different, though. But if you're talking about an unrelated activity, not only that, this is complicated by the third party culpability, which is clearly not admissible, and for a good reason, because it's a red herring.
Your Honor, this is an extension of the crime scene investigation. This is a note that's found at the crime scene. They give it to the investigative team. They have a suspect who is Niall Brenner. Lo and behold, this junk science handwriting points the finger at him. We don't know to this day it wasn't him who wrote it. The only reason we say that now is because they produce other experts that say it's Mr. Durst, but they could...
And Mr. Durst acknowledged that the handwriting looked pretty similar.
Well, but
I recall that testimony.
Yeah, to be clear, Mr. Chesnoff has just said that the cadaver note was found at the crime scene. The cadaver note was not
I didn't mean it...
No, but it describes the crime scene.
Right.
Clearly, it's inculpatory.
Your Honor...
But may I finish, Your Honor?
Yeah, it was gathered by law enforcement. They gave it to this officer whose credibility I should doubt because he focused on a suspect and got a bad handwriting report.
A suspect who they knew had failed a polygraph about this, by the way, Your Honor.
That's also...
Wait, Your Honor, they're mentioning the... Your Honor, can you...
I'm interrupting, but you can.
Wait, Your Honor, can you admonish them? Your Honor, it's misconduct for them to be discussing Your Honor, tell me I'm wrong that the... I'm wrong that the code... Your Honor...
You're procedurally wrong. I love what you're angry, that's the thing.
Wait,
you might be substantively wrong.
Wait,
you're procedurally wrong.
Come on, they cannot. They're bringing up polygraphs, Your Honor, which are absolutely inadmissible in the middle of this case.
Yeah, it's bogus.
No, but you can't do it. It's unethical and it's unprofessional.
Your Honor, I'm not.
That's why you have the code section, Your Honor. Tell me I'm wrong.
Okay, so you're wrong. So when I finish, I'm not bringing it up because it's a piece of evidence. I'm bringing it up because it was an investigative tool used by the police, and then lo and behold, the guy that they utilized the investigative tool is identified as the person who writes the note.
Yes.
Then they switch to Durst. And now all of a sudden, this guy doesn't know what he's talking about, the supervisor's a liar, and we're not allowed to tell that story to the jury, Your Honor? I don't understand it, to be honest with you.
You're on the other issue that this brings up.
Wait a second, no, I'm still dialoguing here with Mr. Chesnoff because of the question and answer here. So,
do we get to dialogue too, Your Honor?
Yeah, we'll dialogue too.
All right.
The jury is entitled to the entire picture of what occurred here.
Well, that's how People v. Hall says.
Right.
Right?
What did you say? I'm sorry.
People v. Hall says you might have some evidence pointing to a third person, and that doesn't come in, does it?
I understand, Your Honor, but we are talking about a completely circumstantial case without any evidence of forensic value except this note, which they are going to use these quasi-scientists to explain to a jury is the aha moment.
I get that part. I mean, you can certainly attack that, and I think it's vulnerable to attack. But this, you can't put in this red herring because it's false on multiple levels, and it doesn't legitimately raise a reasonable doubt. Now, you're trying to say that means. You're trying to suggest, I guess, So wait a second. They're biased. We understand this. So if they're biased against Durst, why are they trying to frame Mr. Brenner? They're trying to frame Mr. Brenner, according to your theory. They're wrongfully going after him. Is that it?
No, Your Honor. In other words, what you have is they first are looking at this. They think Brenner did it. It's a bias at that point against Brenner.
I see. Once they have evidence, then they want to prove their case and close it. that kind of thing.
Or once they have somebody that they think did it, whether they have the evidence or not, once they have something that points to that person, they want to get the evidence together that's going to be able to allow them to prosecute it.
So you want to have a pattern and practice is one, does one instance, let's say that was so? Or do you introduce other cases where they started on the wrong guy before they got the right guy?
If you have a situation where this investigative team goes after somebody because they want to go after him to the point that they actually get a handwriting, and then the handwriting is then approved just with willy-nilly without even really examining it by the supervisor, you've got a situation where somebody is being set up and they're willing to do it because they, I guess, believe he's guilty. And then when they switch and they say, okay, well, we believe this other guy is guilty, boom, we do the same thing to him. And that's the argument that we're making. And if in fact it's really outrageous, forget about the handwriting, because in the sense of whether it's reliable or not, you then have a supervisor who just says, yeah, that's it, that's the guy. On a murder case, you're just gonna stamp it or something?
Wait, but didn't she do, I don't think this is the only case. I'm not sure about that.
We don't know, we made a request for her files, Your Honor.
Right, no, I think that's pending today too, isn't it?
Yes.
So, well, not.
Your Honor, the court made a determination. I informed the defense the day that you made the decision, telling them that if they want to go to the court to get a copy of that information, that apparently the court's going to be deciding whether the court will give it to them or not.
No,
They haven't, so there's nothing pending. We're waiting for them to get it, and if they get it, if the court decides that they get it, then we have a right to get it as well.
I think I do that in open court, don't I?
Yeah, court might decide either way. Your Honor, I just have to add that, first of all, because it's going to be an issue that's going to come up repeatedly, the defense counsel likes to talk about this as a, quote, circumstantial case. Well, there's a lot of circumstantial evidence. We also have what you can characterize as 3 different confessions. Confessions are not circumstantial evidence. Confessions are direct evidence. In fact, just so it's clear, we will be arguing when we get down to jury instructions that the circumstantial evidence instruction will not be necessary in this case because there is other evidence, completely direct, 3 confessions that an individual, just based on any one of them, could certainly decide Mr. Durst's guilt. Number 2, what we really have, Your Honor, and the defense has been very clear, and they've been somewhat transparent about it. The first motion they filed was, your LAP experts are not credible, they're horrible, they shouldn't be able to testify. We tell them, we agree with you, they absolutely shouldn't be able to testify. They then realize, wait a minute, we want to put on a dog and pony show, putting LAPD on trial, etc. We want them to testify. So then they come up with, when they lose the Sargon issue, they say, well, you know what, though, we want to bring it in for a completely unrelated purpose, third-party culpability. They don't come close to meeting Hall. Again, and the court, gave a pretty easy synopsis. It's pretty simple. In the end, what conspiracy could there be? One person made a mistake and one person committed misconduct when they identified Niall Brenner. They said in 2003, 12 years before this case was ever filed, 2002, excuse me, 13 years, they said that in fact they made a mistake and it was not Niall Brenner.
So let me give you a hypothetical. Let's say that if the point is not to say that Niall Brenner did it, but the point is to show that the officers were biased. What if...
Wait, which officers? The officers?
Yeah, I mean the whole team, I guess.
Well, you have to...
Well, I don't know, but let's just to set that aside for a moment. We'll get back.
Yeah, it's kind of setting aside the whole...
The police, the police were biased against Mr. Durst. So, now, to that point, let's say that they say you investigated someone else. You had a handwriting, you took a polygraph and a handwriting exemplar, and you turned out he wasn't the guy.
Well,
or you want to add that it's, they want to add that.
First of all, as the court's aware, the mention of a polygraph, either the offer to take or the results, is inadmissible in a trial, in a pretrial motion, in a courtroom.
It gets in though. It gets in when people offer to take polygraphs, or
Your Honor,
threatened with a polygraph, and then they testify.
Your Honor, it gets in.
It does come in.
Your Honor, it gets in.
I know it's inadmissible, but it comes in. Sometimes.
It can only come in under law if both sides stipulate that it comes in. We're not going to stipulate.
Right. No, I don't, it shouldn't come in, but this is a hypothetical here.
It's a scary hypothetical.
Okay, I'm sorry, it's scary.
It's a scary hypothetical.
This is weak. All right, so isn't there some basis for impeaching an officer for focusing on a person and going to great lengths to try to demonstrate the person is guilty rather than to rule them out?
No, here's the problem that you have. First of all, these are not officers. These are forensic document examiners whose only part in this case, they were not part of the investigation at all. They were to do one thing. They were to look at the writing, and they were to give a determination whether or not it matched other writing or didn't. One person screwed it up by their own admission, made a mistake, an honest, but a mistake of competency that goes to Sargon. The other one didn't even look at it. So obviously, there can't be any, at that point in time, there's no investigation that's going on.
So then do they employ the LIE detector?
Wait. You mean you're asking about the order of what happened?
Yeah.
Well, I mean, gosh, I hate even dignifying it, but I will tell the court, based on my memory, it's as follows. Niall Brenner, because he ended up going into the house after, let me back up. Niall Brenner was acting very strangely after Susan died. He was acting strangely after Susan died because they had a very, he in essence did everything she asked. He didn't have the guts to tell her, get lost, I haven't made any money off you. He would have to go down to her house to swat flies. He couldn't get rid of her. When she died, his response was almost joyful to some degree because he was relieved of a burden that he could not undo on his own. He ended up making those comments to other individuals. In addition, it turned out that he had gone inside the house through a window after the police had been there. Now, as the court's aware, he did not do that on his own. In fact, Susie Harmon, Susan's close friend, went through the window first, told Niall about it, and he ended up going through. So, in addition, when he ended up going for an interview at LAPD, he ended up signing in, and he signed with block letters. Bill Lever has said that, you know what, I made the cardinal sin of a handwriting analyst. I looked at what was similar rather than what was different, and because he wrote in block letters, I ended up thinking, you know what, could it be him? So they then went and got exemplars, but before they did the handwriting comparison, they gave him a polygraph. As the court knows, there are many reasons why individuals fail polygraphs other than individuals being lying and being untruthful about what the nature of the polygraph's about.
So let me pause you. So in order for this really to implicate or to suggest a lack of a bias on the part of the officer would have had to encourage the handwriting expert to make that comparison and find that it be positive, right? I mean, that would be bias.
Well, so you would have, so if you're talking by the bias, meaning the original detectives biased against trying to get a case on Niall Brenner?
Right, exactly.
Yes, and in fact, what we had and there's been no evidence presented whatsoever, the officer, the detective, has a motivation, Your Honor, not knowing anybody. He wants to find who the true killer is. So he went with what they told him. There's been no evidence whatsoever that he in any way interfered. They've been interviewed. They've given statements. There's been nothing that has said, you know what, we gave this opinion because of pressure. They were very clear. Bill Lever says, I screwed up. I made a cardinal mistake.
So it seems to me that they developed, it's almost as if the technique is to be biased against a person to test that bias. Right. In other words, the bias is a hypothesis that you test, that then when falsified by proof that evidence that he could not have committed the crime, then they become quote unquote biased against Mr. Durst, and they continue to investigate him, yet it's never been falsified, right? Hence the prosecution.
You know, I'm going to tell you, I did not understand where the court was going.
All right, I'm just trying to work with you here and trying to understand whether there's some basis for admitting this, even if there's a concession that he could not possibly have done it.
Your Honor, can I add something?
Yeah.
As to the court's point or question earlier to Mr. Lewin as to whether somehow this would be supportive of some grand conspiracy amongst law enforcement, and I understand it's a hypothetical, but I think it's an important distinction to make. And are we talking about a grand conspiracy amongst LAPD? Are we talking about a grand conspiracy amongst LAPD and NYPD? Are we talking about a grand conspiracy amongst LAPD, NYPD, and the New York State Police?
I think the FBI is part of it too.
The FBI? I can go on.
Galveston.
Then we add in, is this
I don't really
also,
understand.
may I finish, please?
I'm
Can you call
sorry.
him as a witness?
No, what I don't really understand, Your Honor,
do I get to-
there's selective accusations. 1 minute, Detective Struck is no good when they want him to be no good. Galveston screwed up the case when they want him to.
Okay, I got it. Okay, yes.
Go.
Okay. I must have been making some headway. So, then we get to Dracula and Smerlin. Hit the ground running. Is this grand conspiracy somehow extend to them? And I think it's important for the court to consider and to understand.
Conspirators cooperate.
True, but they didn't know him at the time. The detectives on this case weren't even assigned, weren't even involved. Were you guys in RHD back then? No, weren't even in RHD, the Rhyming Homicide Division back then. They're the ones dealing with Dracula and Smerling. They're the ones gathering evidence now. They're the ones who have marshaled much of the circumstances which we're going to be presenting to this jury. And I think if the court does find some remote or probative value to whatever conspiracy the defense is alleging, I think it would be substantially outweighed by any possibility of confusion of the issues, undue influence, etc.
I think the only way it comes in, Mr. Chesnoff, is there may be, as I was suggesting before, there may be answers to questions which are legitimately posed that you may link together in a theory such as what you have described. But in order for me to admit this evidence, you have a heavy burden, and you would need to make a motion in advance of trial why that ought to come in. And I'm not satisfied by what I've heard so far, but I'm not going to foreclose you entirely. I understand that there could possibly be some, but as Mr. Bellion has described, the opportunities seem quite remote.
Well,
Unless you paint with a broad brush and say, everybody, that side of the room is biased against me.
I will attempt to compose potential cross-examination in order to fulfill our responsibility, because the way we look at it, if a murder that he got acquitted of can come into court, the mistakes made by the police should come into court too, Your Honor.
Okay, but, all right, but I mean, the people actually made quite a showing of a substantial similarity as to each aspect of that evidence. So it's not, one for them, one for you. I mean, it just doesn't work that way. However, on that note, as far as Professor Denbo, I don't see why he shouldn't testify. Now, given the limitation that I described, for instance, that for him to testify, certain states don't allow it. I don't care. That's no good. But as far as criticizing the science and supporting the idea that one cannot reliably identify or compare.
That's what we plan on calling him for.
Now I have the floor, not you.
Your Honor.
Please be seated, Mr. Lewin. I'm making my ruling. That is my ruling. Okay, yes, you wish to be heard.
Yes, Your Honor.
Yeah.
Two issues.
Yes.
Can the defense be admonished once and for all? They cannot bring up offers to take polygraph or polygraph results. I want to make sure it's on the record, Your Honor, because it's misconduct. I've put it in 2 different motions now. The court's told them about it before, yet here they are today talking about polygraph results.
All right, Mr. Lewin, you heard my ruling. They're not going to be mentioning evidence that is not admissible.
Okay.
They can't do it in the opening statement. They can't do it, I'm foreclosing them. But subject to your motion.
Thank
You can
you.
make a pretrial motion.
All we're doing, Your Honor, was trying to provide the totality of the circumstances to understand the police procedures that were utilized in the course of this investigation. We know our responsibilities in terms of saying somebody failed a polygraph.
Can't mention a polygraph, period. They're not allowed.
I'm just mulling over this totality of the circumstances part. I'm not sure that's a good idea either.
No, the second issue, Your Honor, that comes up related to this is the defense at different times in this case has made third-party culpability arguments that now Brenner's the killer,
Yeah.
that the mob killed her, that Eve Askin killed her, that potentially Sarah Kaufman or Paul Kaufman killed her. So we have not received any third-party culpability motion from them at all. And Your Honor, as the court knows, and this is my concern, if they intend on offering third-party culpability evidence, either through cross-examination or through their own witnesses, it needs to be ruled upon pre-trial. Now, the court, Your Honor, the court gave a deadline of originally May 24th for these motions, and I brought that up. We're now almost in November, and they haven't filed. Their expert witnesses are due November 15th. We are still supposed to be litigating the parts of the statement, the confession Mr. Durst made to myself and detective.
You said that before, Your Honor.
That they want out. None of
Your Honor, we have an
these
agreement
let me
given to
finish.
you by the 12th of November, yet you insist on repeating.
So, Your Honor, so what I'm saying,
You know, this is our court reporter.
I'm gonna-
No, I'm not gonna have this impact.
Your Honor, I didn't interrupt them when they spoke. So,
I know, I think you guys can do it.
so, Your Honor, very then quickly and briefly, November 15th is the deadline for them to give their expert witnesses. We are way past the deadline for them to submit their motions. If they are planning on filing any third-party culpability motion, Your Honor, it needs to be filed by November 15th. In addition, and as important, we need to set a date to litigate the statement, the parts of the statement they are objecting to.
Let's do the 15th.
The 15th?
13th.
Your Honor, that only gives us, it's November. Oh, November, the 14th of November, Your Honor?
So, the January date, I think, we discussed, the possibility of delay.
November 14th for the.
Hold on a second. Well, with regard to the other provisional years for returning your, I'm starting a trial, another MRSA on the 18th.
So you're saying November 12th, Your Honor, for the motion?
Well, I want to check. I don't want to do
The motions in limine that we filed, Your Honor? Good?
Well, I wanted to, we talked about when you were turning over expert reports on the 15th, but that's not a good day for this. Of course, here, anything such as the statement. Now you wanted more time for the statement?
Your Honor, what I understood was we would submit a written analysis of the interview by Mr. Wheelan, Mr. Durst, Mr. DeYarn was finished. And my understanding was you would review it and make your ruling as to what was going to come in and what was not going to come in. Do we need a hearing?
We need a hearing. We have a right to be heard on whatever you are asking for, the judge is going to decide. We want to litigate like anything else.
You agreed that we would get it filed by November 12th, Your Honor. That was what Mr. Wheelan and I agreed.
That is true. I told him, if it's filed by November 12th, we'll be ready to litigate it November 14th.
I'm waiting.
On the 14th, Your Honor? That'll be fine. Well, yeah, I guess I'll argue that.
And Your Honor, so on that date, then, they'll also have the third-party culpability in essence in limiting motions that they haven't filed regarding third-party culpability or this issue ought to be filed before that date in time for us to respond.
We're finding something, I thought we found something that just doesn't come out of the
What's that, Your Honor?
It's unlikely that a grant that motion would miss that.
But no, Your Honor, but I can't, Your Honor, I agree, but I can't be presumptuous enough to say, don't worry about filing it, right by trial, Judge Clay won't grant it anyway. I don't think he will, because they don't have the evidence to back it up, but again, they were supposed to file this stuff months and months ago. I bother them frequently with emails, phone calls, et cetera, they don't do it. So it needs to be.
I appreciate the fact that we do a lot of this, pre-trial. Sometimes this thing's done the day for, jury selection. That's typically what I'll do. I'll set aside one day for these motions before, long murder trial, of course, this is a long murder trial. So I appreciate doing these things in advance. I don't think it's.
The third party becomes important for us to litigate, Your Honor, because let's assume under some crazy scenario, which I can't come up with, the court allows third party public hearing evidence on these issues. That means we're going to end up having to call witnesses we would not call and do work on off the call.
All right, I will, my understanding is on November 14th, we're going to have a hearing on the filing that we're going to make before November 12th on the questions of Mr. Leland's interview of Mr. Durst, correct, Your Honor? And that will be what will be heard on the 14th.
Yeah, now, as far as let's talk about, let's talk about the trial date. So, I was very pleased in the chambers today that we had, I think we're approaching an agreement on some stipulations, and we've also discussed a jury selection procedure that I believe will reduce the length of the trial by 1 month. That's why I am comfortable in agreeing with the defense request to the 10th.
I think you said the 11th of February. I thought that's what you said, that's what I heard.
Right. So,
Yeah, I believe the 10th is the court holiday, I think. Is that right? I'm not sure what President's Day is.
I have 1 day of rest before,
10th is a Monday.
I know that it's,
I'm not sure if that is something.
It's not, it's not President.
No, I believe it's not.
President's Day is on the 17th.
Did you want to do the 10th thing, Ron?
Oh, we celebrate the birthday here. Well, all traditional.
So what day would you like to do it to begin with?
Right. And Mr. Durst, Mr. Durst, we worried about February 11th. I was just agreed with an earlier date. Getting right to trial by January the 13th. Is that agreement to 11th February? The 11th.
Can you pass the call for February 11th? Is that okay with you? Yes.
Agreed? Yeah.
Yes.
That agreed. Agreed then.
Thank you.
No further continuing.
Your Honor, and can court just, I know we discussed in chambers, but
Yep.
can we just put on the record that it's the court's position that in essence, as long as there's one lawyer available for each side, we are doing this trial February 11th. What's that, Your Honor?
I don't take positions, I make orders.
Well, Your Honor, well, you order that there is,
As long as it's just me and
I
John.
rule.
thank you.
That's right. Old school, like I used to do it.
That's right.
One lawyer, what's his second chair?
Exactly.
All right.
Your Honor, sorry to interrupt. I think we might have ordered Mr. Oliver back in January, so if we do it for the February date?
You want to get my brain?
When the court had said,
Who's going to,
I think we said the January date because we're still going to be here on the January date, correct, Your Honor? So we're still going to be 113, and then the court said if I'm satisfied, then the court gave me permission to put him on call.
That's right.
Thank you, Your Honor.
Okay, now, do you want to talk about your motion to unseal that document?
Yes, please.
Okay, I'm gonna grant it, but I'm gonna make it subject to a protective order, and I'm gonna order you to, I'll find the people and with that protective order and with that, you can get it.
And so we would get a copy from you, from Mr. Lord?
If you are asking me to, I'll mail copies of the court will send you.
Okay.
Your Honor, then the final thing is, are we able, because we have that Steinman is still here, are we able to go back into chambers outside of the, regarding the issue of, some issues I wanted to point out to the court very briefly on, can be off the record, on cross-examination, privilege, invocation in front of the jury with the client, because she's here, I want to make sure the court is aware of this information in advance.
Yeah, I think we should go.
Thank you, Your
Your
Honor.
Honor, I would like to say, look at the person who should be respectfully leave today is Holden. Now, I'm not all familiar with where he was going.
How's this? How about if we all choose them out and you'll move on Jeff this time or make
My suggestion is,
I'm not making any rulings or.
I want to ask you,
we listen, and then I'm sure that's it. We can put it in a motion and eliminate it, and then we can.
Well, let me just send this an email. It's like, just the 10th.
this will be helpful, Your Honor, having this chamber discussion will be helpful. Thank you, Your Honor.
Okay, can we come back?
No, not until I adjourn, right? We're adjourned? We need to adjourn? We're coming in, so as far as your other motion, 256, that's.
Right, because we're going to do it on November. Oh, 356, Your Honor, yes, the point of the 356 motion is to make sure that the court, that was really more for the defense. I assume, Your Honor, did the court agree with the legal? Thank you, Your Honor.
All right, and then,
Wait, Your Honor, and that means so motion granted with respect to 356.
we're gonna do a hearing, you want to do a hearing on the motion?
Well, I mean, there's not much to, it is what it is. 356.
The motion is, I don't think it's going to be more than, so on the record, you're not adjourned yet.
One second.
Quiet, please, for some moment. I'm
I have an option.
Let's see,
You have been modified with change from your
we'll take it up on the
14th, Your Honor.
November. That'll be in November.
Thank you, Your Honor.
Department 81 is adjourned.
Hey, Bob.
Yeah, I got it right here. Yeah, I'll turn it down next one. No, I was in trouble. Good to see you.
John, can you fire this up? I really do have to go to.
Yeah, I'll make this quick, Dave.
I'm